is now in session.
Hey, please be seated. Good morning, everybody. Welcome to the Arizona Court of Appeals for Division 1. I am Judge Jacobs. To my right is Judge Perkins. And though Judge Weinsweig is not seated to my left, your right, he is participating remotely because he can see the live stream of this and he has the ability to ask questions through us here. So those are the three of us. We're here for oral argument first this morning in the case Butler versus Larosk, Civ 230576 Family Court. As you may know, we record and live stream the proceedings, so please state your name and the name of your client clearly when you begin so that it's there for the record and for everybody who is watching outside the court as well. You have a maximum of 20 minutes per side. You are not required to use, but you are permitted to use all of that time. We do ask you to keep track of your own time on the podium, and the clocks reflect how much time you have left, so please, if you're the appellant, please mind your time as to how much you would like, but if you state the amount you prefer, we'll also keep that in mind and try not to roll over your ability to reserve some time. Please also keep in mind, finally, we have read the briefing, studied the record, and discussed the case in conference this morning at 9 o'clock. So, appellant, when you are ready, you may proceed.
Thank you, Your Honors. I would like to reserve a couple minutes, so we could keep that in mind. I would appreciate that. I'm Elizabeth Fitch, appearing on behalf of my client, Corey Butler. I want to start looking at the lens in which this case should be looked through. And one of the most poignant and profound and joyful moments in any parent's life of a wanted child is to have that baby put into their arms. And this is a ubiquitous experience of all parents and has been recognized by the courts throughout this nation, including the U.S. Supreme Court. And I think one of the most poignant statements made by the Supreme Court says it best, so I'd like to quote from that. The Supreme Court stated, "The intangible fibers that connect parent and child have infinite variety. They are woven throughout the fabric of our society, providing it with strength, beauty, and flexibility. If it is self-evident that are sufficiently vital to merit constitutional protection in appropriate cases." This is an appropriate case for that. The U.S. Supreme Court went on to recognize that the importance of the biological father's connection, and again, I'd like to quote, the significance of the biological connection is that offers natural fathers an opportunity no other male possesses to develop a relationship with his offspring. If he grasps the opportunity and accepts some responsibility for the child's future, he may enjoy the blessings of parent and child and may provide valuable contributions to the child's development. This has also been embraced by Division 2 in the Pinal case.
So, counsel, we very much appreciate and agree about the gravity of the interests and the constitutional nature of certain interests at stake here. So I'm going to try, for the benefit of time with you, to take us on Google Earth down from like kind of the satellite level to the you can see the garage level here. So the constitutional claim that you've brought is one sounding an ineffective assistance of counsel. It's not a criminal case. It's a case following after Royce. And so we know that fundamental fairness is sort of the thing that we are looking at here in terms of the constitutional interest that your client has appealed to our court. So looking at this, your client on day 24 had notice from day 1 to day 24. Here's what I have to do. I have 30 days. It's a statute of repose. You're charged with knowing what's in the Supreme Court's case in Cox. You have 30 days to do it. Why is it that you can hand it off to a lawyer on day 24, and if the lawyer doesn't file by day 30, that error not only is an error, but violates constitutional fundamental fairness in a due process sense?
I think the recognition that, first of all, this is not a lawyer, this is a truck driver, and that, as the court has recognized in its minute entry, in this case, the trial court, and the courts have recognized, this is not a simple process. This is complicated. In addition to that, Corey was attempting to figure out that process. The letter, the notice that he received from Catholic Charities, he saw it. They were there to give him help. So he began the process of trying to call Catholic Charities, get help. And as the trial court recognized, that the evidence is undisputed that he couldn't get the help he needed.
So here's the thing, counsel, and it's kind of a horns of dilemma kind of argument from my point of view as I try to analyze it with you here. Are you saying that if he never hired a lawyer and didn't file anything by day 30, and he files and serves on day 42, which is what happened here, day 42 is the service, the fact that he had a hard time understanding the documents, that would be a violation of fundamental fairness, abstracting the lawyer out of it? Or would he lose under the Cox case because it's a statute of repose, no matter how unfair it is?
I think in that particular circumstance, he may lose, because what's important about due process is we cannot look at it in a vacuum. We have to look at the particular case, we have to look at the particular facts, the particular individual, and the particular circumstances.
I agree.
And in this case, it's different.
I agree. I agree it's a different case and it presents different facts. But if your client, having not retained a lawyer as of day 24, would be chargeable with filing and serving mother by day 30, why does that change if he had constitutionally adequate notice on day 24, which is he might lose, your prior comment, and I agree. Why does he suddenly have constitutional protections because he hired a lawyer when that doesn't happen by day 30, when he had constitutionally adequate notice on day 24? That's my issue with the case, and I'd love for you to help me understand it better.
I think because in this particular case, and again, we have to look at it through this lens of this particular case under these particular circumstances. In this particular case, he did choose to retain a lawyer, and he's entitled to rely on his lawyer. So the question is, when you hire a lawyer who is competent in this particular area of practice, and he's relying on that, he has now been deprived, because of the ineffective assistance of counsel, of his due process rights. Fundamental fairness requires, in this particular case, under these particular circumstances, that he be given his due process rights, which in this case, he took all the necessary steps. So if you look at what the case law says, his fundamental rights are not because he's complied or hasn't complied with the statute. That's a factor. But you also have to look at the most important factor is, did he take immediate and persistent actions? Did he embrace his opportunity to bond with his child, to create a paternity opportunity? It's an opportunity lost because he has a fundamental fairness right to do that.
Is there any indication in the record that between days 24 and 30 that father had communications, not his wife, but father had communications with counsel or took affirmative steps between days 24 and 30 to safeguard that his lawyer would be doing what the notice told him to do?
I'll answer it this way, is that his wife was acting as his agent. So he's entitled to rely on a wife. I mean, this is a relationship. As you can see from the paperwork, because you've obviously read it, she had a vested interest in doing this too. They were acting in concert. They were acting together. She was his agent. If you think that we need to have additional facts in the record to support that, you have the ability to do that. You can remand it back so that we can do those, discover those additional facts. But that she's acting as his agent and is entitled to do that. So he's relying on her, and they are both relying on an attorney who holds themselves out as competent in paternity actions.
The counsel who followed them, who argued the matter, I think it was to the Superior Court, I'll just say below, the subsequent counsel did not argue ineffective assistance of counsel in that proceeding, even though it was a different lawyer, correct?
Different lawyer, but the same firm.
Same firm?
Yes, correct.
Okay. Thank you.
Does the failure to have raised the ineffective assistance of counsel at that point nonetheless give us a little bit of an issue with waiver?
No, I do not believe so. I believe that you have the authority and the right to address ineffective issue of counsel at any time. Any due process claim we can bring in front of you.
Waiver is typically something that we can overlook. So I agree with you that we can. I guess I'm just kind of trying to nail down, isn't there potentially a waiver issue because there was a subsequent counsel who did not identify this as an issue and could have done so to the Superior Court, in which case we could have had the benefit of the Superior Court's findings or evaluation of that claim?
I would say that no, there is no issue of waiver because a waiver of a constitutional right, I don't believe there's any case law anywhere that would support that. When you're asserting ineffective assistance of counsel in front of a court of appeals, you have the authority to do that. But what I will say, if there was a waiver issue here, it can be cured. And the way it can be cured is, again, you can remand it so that that issue can be addressed by the trial court.
Thank you.
Thank you. So fundamentally, if you look at the balancing test here, because that's really, there is a 4-step analytical process. One we've talked about already, which is the general due process, that it's a particular place, a particular time, for a particular person. Then we're looking at what is the due process rights of Corey as a putative father in these circumstances. And what the case law says on that is that, and it is in, one moment here. It is, and I want to quote it again, so I apologize for the moment, but in Division 1, in the Richard M. case, the case law states, and I think it's compelling, that the private interest of a man in the children he has engendered warrants deference absent a potential countervailing interest. And a potential father whose parentage has not been judicially established does not possess the fundamental liberty and as a legal parent unless, the most important word in all of this, unless he takes significant steps to create a parental relationship. The corollary must be to that is that when a putative father does take significant steps, then he does attain the same fundamental rights as a legal parent.
So your argument would be the act of hiring the lawyer is the significant step here that preserves that right against the countervailing interest, is what you're arguing.
It is exactly, and one of many steps. So when you're looking at in totality, that is a significant step in and of itself. But when you put that with all the other things that Corey did, he reached out to Catholic Services over and over, trying to get help. When that didn't happen, they attempted to fill out their own paperwork, realized that this is beyond us, and that is when they retained Valley Law Group. At that point, there's still 7 days in which to get the petition filed and get the mother served. Once they turned it over to their counsel, who they relied on and trusted on, they were very responsive. So if you look at even the history between the counsel, whose failings is objectively unreasonable, without a doubt, but when you look at whether Corey was being persistent, it was very responsive. Within hours, every time the attorney sent his wife something, they responded within an hour both times, I believe. That's what the record will show. So he's very responsive. So that totality of that demonstrates that he took advantage of the opportunity to build this relationship, did the way he understood he was supposed to, which was retain an attorney to file a paternity action, and did everything he knew how to do, everything within his power. He took those actions.
Could you talk to me a little bit about how you would distinguish this case in terms of these, affirmative actions, objective failure by counsel? How do we distinguish this from Cox?
I don't think Cox raised constitutional issues. If you look at it, what Cox talks about is equitable remedies. And if you read carefully that case, the Arizona Supreme Court was not presented with any constitutional arguments. They were presented with equitable arguments. And I do think the Cox case is important, but not for the reasons that have been cited by my worthy opponent. But what is important about Cox is that they were seeking equitable remedies, and the court held that equitable remedies were not applicable because this is a statute of repose with substantive rights. And why that's important here is it goes into the Lassiter three-prong test, because he has lost a substantial right, and he is divested of any opportunity to participate any further once that right was divested. And the only reason he was divested of that right was because his attorney failed to timely file a petition. And so I think that's a very different circumstance. I don't think the court in Cox addressed constitutional arguments, number one, and number two, the facts of the case are quite different.
In what way are the facts different?
The facts are different in that Corey repeatedly, again, it gets back to the constitutional question here, which he was immediate and persistent action throughout, up until the time that he found out that, the petition was dismissed.
Well, Cox actually presents facts that are significantly worse from the standpoint of a father who's trying to safeguard their rights, because there were affirmative attempts to kind of evade, and that wasn't really occurring here with the mother, right?
There was no attempt to evade here. But again, we can't compare facts, because we have to look through the lens of this particular case, with this particular plaintiff appellant, with these particular circumstances. So while Cox has some similar facts, and that is a bad fact, I will agree, that is an unfortunate fact in that case. But in this case, what's even as equally concerning is that he relied on an attorney to represent his interests in this paternity action so that he could establish paternity, so that he could have what every parent of a wanted child wants, is to have a relationship with this child, to be able to hold this child in his arms. And he is divested now of any opportunity to do that. So under the analysis, the Lassiter three prongs, there's no question that his interests are paramount, and that the state's interest, when you compare it to, is, I believe the word was mixed. It's a mixed interest. So those three.
Well, Cox, the Supreme Court explained the sort of important social policies behind finality for the sake of the child. I don't think it's a minor interest. Counsel, you don't think it is either, I take it, right?
I do not think that is a minor interest. I do think that it's important to recognize that the child's interests are very, very important to consider in this. But I think there is also, evidence or empirical data that depriving a child of their natural parent can lead to abandonment issues, can lead to all kinds of problems. It's not unusual for a child who has been adopted at some point start to seek out, where is my natural parent? I want to know them. And so I do think the child has very important interests, but that doesn't undermine how important Corey Butler's interests are in this proceeding, and that he was wholly deprived of that. And he has no other remedy at this point.
You said you wanted to reserve a couple of minutes. I have you at 2 minutes and 9 seconds.
Yeah, thank you.
Thank you, counsel.
Good morning. Corey Stewart for appellee Audrey Larosk, not to be confused with Corey Butler, the petitioner in this case. I do think it's meaningful and relevant to just touch briefly on the adoption statutes that we have in the state of Arizona. Very specifically relating to 8106, there's two time frames that are very significant that have been litigated and continually upheld by Arizona courts. One deals with registering with the putative father's registry, which must occur within 30 days of the birth of the child. And the other one is this very specific deadline pursuant to ARS 8106J, where you serve a notice on a potential father with a notice that complies with ARS 106G. Courts deal very differently with these two classes of fathers, in essence. A father who registers or who's not named by the mother is what we call a putative father, and a father who is named by the mother is what we refer to as a potential father. There's a case from Division I just 2 weeks ago that discussed this distinction between the putative and potential father. What's important with both of those is, every case in Arizona that's discussed these two timeframes has upheld these timeframes as strict deadlines. In relation to the putative father's registry, the Marco C. case, he registered on day 31, and the court still upheld that as a firm deadline that must be abided with. The other thing that I think is significant and that was, somewhat talked about here is that Mr. Butler's interest or ability to file his paternity action did not begin the day that he was served with that potential father's notice, telling him, hey, you have 30 days to file and serve a paternity action. Mr. Butler had 9 months from the time that he had sexual intercourse with mother to be able to file a paternity action. ARS 8106F says sexual intercourse is deemed notice of to the putative father of potential pregnancy. And so it wasn't as though this is the first time that he had the ability to go and file a paternity action. He could have done it at any time after he had intercourse with Miss Larosk. The other part that I think is significant is there's been some conversation about how this is a difficult process to complete. There's self-help forms on the Maricopa County Superior Court website to file a paternity matter. There's a very extensive packet that explains to every person who looks at those forms about how to fill them out, how to properly serve. So I dispute the contention that somehow this is a significantly difficult process for someone to accomplish.
Counsel, could you speak to the point I raised to opposing counsel earlier about how can the notice in the statute be constitutionally sufficient if you're not going to hire a lawyer on day 24, but it becomes insufficient by day 30 if you did hire a lawyer? I'm stuck on that.
I don't think it does. I think that these statutes, based on the fact that they've continued to be upheld, and even the language in Richard M. tells us that these statutes on their face are constitutional in the sense of the notice that we're giving to fathers. And so whether he hires a lawyer or doesn't hire a lawyer, in my opinion, doesn't change in any way the analysis of his constitutional protections. He still, regardless of whether he hired a lawyer, the obligation to meet that 30-day deadline to file and serve is still his as the potential father. Hire a lawyer, don't hire a lawyer. That's still his obligation.
Well, it seems at some level the question is whether you're right that father has constitutionally adequate notice on day one. I'm not concerned about 8 months before that or whatever, but I think that's the thing I keep at least recurring to. So can you point us to things in cases after Royce where one of our Arizona courts has explained how these statutes provide adequate notice since Royce or not?
I don't know that there is a case since Royce.
Maybe this is that case.
Maybe this is that case, but I don't know that there is a case since Royce that has specifically addressed that. And I think one of the things that's significant about Royce, and I understand that, appellant isn't asking this court to say that Royce is dispositive. They're simply asking this court to use the same analysis as Royce. But one of the things that I think is important out of Royce, and quite frankly out of many of these cases that deal with these issues, is we're consistently using the word parent, right? Royce deals with termination of parental rights in severance proceedings. It doesn't specifically say this, but at least in that context, it was a severance proceeding initiated by the state. And so certainly there's more, in my mind, protections that should be afforded to parents. In this case, Mr. Butler is not a parent, right? He's a potential father, and they have different rights than parents do.
So what's your authority for the different constitutional dignity of the rights of actual versus potential versus putative fathers? Because if it turns out that the putative or potential father is a father, then they're that person who has that full bundle of rights. So where's this constitutional distinction grounded, counsel?
And that's where, once you've established that, that's what then gets you those additional protection as a parent. I would refer the court to the Richard M. case, which we've already talked about, Richard M. versus Patrick M., and I'll quote from it directly. It said, as an unwed father's parental rights do not attain fundamental constitutional status unless he takes significant steps to create a parental relationship. Richard M. did not comply with that statutorily mandated paternity process, meaning his interests are as a putative and potential father, not the more expansive rights as an actual father. Right? So Richard M. was dealing very directly with this issue of what rights do potential and putative fathers have and what rights do actual parents have. And so I think it's a significant distinction, I believe, in this case is, in my opinion, what appellant is asking this court to do is to treat appellant as a father instead of treating him as a potential father, which is what he was, and it still is.
But isn't that argument a little bit dangerous for you? Because when you're reading me the significant steps language out of Richard M., that sort of plays into opposing counsel's argument. And she says, well, it's a factual matter whether I took sufficient steps. I mean, that's...
I understand that, but I think by the court then saying he didn't comply with the statutes, I think that is the court implicitly stating that complying with the statutes are those significant steps. I mean, the significant step is compliance, is fulfilling it. It's not thinking about fulfilling it. It's not half filling out the paperwork. It's filing and serving within 30 days. That is the entire significant step.
I guess that kind of bootstraps your way through the whole question we're considering, whether it's constitutionally subnormal, the process in 8106G as applied to this gentleman. That's the point. And you're saying, well, you didn't do the statute, so you can't have a constitutional argument. There's an element of circularity in that position.
Correct. I mean, part of the reason in our response brief that I don't go through all the Lassiter factors is I don't even think we get there, right? Because we're asking for constitutional protections to a person who isn't entitled to them. I mean, that's the baseline level of our argument for the court is he doesn't get those constitutional protections because he didn't comply. And making this distinction of hiring a lawyer or not hiring a lawyer doesn't change his obligations under the statute. And there's certainly are facts that I think that have even been stated today that just simply aren't on the record about, we don't know what kind of diligence he actually had with his attorney that he hired. We don't know what documentation was provided to the attorney that was hired. I mean, that's information that isn't even on the record for us. I mean, in essence, the record that we have before us is he hired an attorney on May 8th, and they filed and served late. I mean, we know that he hired an attorney 6 days before, but we don't know what occurred in the intervening time period between Mr. Butler and his counsel as far as that goes. And so to say that he diligently pursued and did all of these things, we don't actually know that that's true before the court today. I do want to talk about the Cox v. Ponce case because I do think it's relevant because while the nuances of the facts may be different, I think the facts in general are very similar, right? Somebody hired a potential father, served with a notice, hired an attorney failed to file and serve within the deadline. I disagree that the Cox court didn't consider these constitutional protections that we're talking about. I think that we can call them by a different name, but they considered, it's in the case, they considered excusable neglect as an equitable remedy that they were not entitled to in the Cox case. And excusable neglect, I mean, the definition of excusable neglect includes failure of your retained counsel basically to represent you adequately.
But wait a second, counsel. Even though you're totally right, excusable neglect crops up as a tool in the constitutional area, but you're not literally saying that Arizona or federal constitutional issues were expressly raised as such in Cox. That's not correct, right?
I agree. It's not spelled out the way that it's being spelled out in this, but I think it's important. I think when they recognize excusable neglect, it's recognizing the assistance of an attorney in helping you and that not being a remedy that was available. And so we can call it by a different name, but I think they were still contemplating these issues. I understand it's not spelled out in the Cox case specifically as, ineffective assistance of counsel, but I think excusable neglect translates over to that.
So does your argument hinge on, thinking back to the colloquy we had about 4 minutes ago, does it hinge on father not being a father but being a putative or potential father? If that's wrong, do you lose?
I absolutely think it hinges on father being a potential and not a putative father.
So then let me try a hypothetical on you, because this is really interesting. You got me thinking about this with your argument. It's a very interesting argument, counsel. So let's say mother and father exchanged correspondence, and they both know to a certainty that father is father. But he gets notice under 8106 G and J. So that's father wins because he's the actual father if he doesn't file in 30 days because he has more constitutional rights? Or instead is the question whether G and J provide him with fundamental fairness and so he just loses?
Yeah, I think if, even in the hypothetical you talk about, if mother and father have a conversation at the beginning and they kind of, I assume what you're saying, they verbally agree between one another, well, yeah, you're the father, we know you're the father, you still would have to serve him, in order for that child to be free for adoption, right? You still have to serve him with his notice under 8106 G and J. That provides him his constitutional protections, right, is being served with those. And so even in that hypothetical, he's not a father. The way that there's only a few ways that you become a legal father. One is you're married at the time of, the child is conceived and born. You're married, you're a presumed legal father in that situation. You sign an affidavit or declaration of paternity at the time of the birth, and you're put on the birth certificate, or through a paternity action and a court order that then claims that you're a father. So anything other than that doesn't get you to the qualifications of a father. That's why these steps are so important, because these distinctions between classes of fathers is very significant. Putative, potential, and legal father, those are our three classifications. And the distinctions are very, very significant. And in this situation, Mr. Butler is only a potential father. And his rights under our statutes are to be served with a notice pursuant to 106 G and J. That's his constitutional protection, is being served with his notice. And then when he doesn't comply, that burden is on him. He has to comply. It's his burden. It's nobody else's burden for compliance. And so the further concern that I have with the argument that appellate is advancing is that if we're going to uphold this kind of sort of substantive right to potential fathers in paternity proceedings to have effective assistance of counsel, I just wonder what other issues this opens up for the potential court system. Is it going to open up an issue where we think we have to start appointing fathers in paternity cases counsel that's going to then be funded and covered by the state? Like, what other things does this get us to by saying they have this particular right prior to their rights actually even being established?
You said if we're going to start upholding this right, you're not questioning that Royce is good law when you say
that. Oh, no, I mean in
okay.
relationship to in paternity proceedings, right? Royce is good law for sure, but I think Royce is very, very limited in the context of termination of parental rights proceedings.
So you limit it to terminations, dependency termination context, people in that process, not this.
Absolutely, and I have no problem with that, and I think that's what Royce stands for.
And do I understand your limitation there is based on this categorization? In other words, the right attaches to a parent who is a established legal parent as opposed to one who is not yet established
Absolutely.
legal parentage.
100%. And I think that's a significant fact in Royce. These were parents, right? That nobody was a potential father, nobody was a putative father. These were parents with already established rights. And so unfortunately, it's just what it means. There are certain rights that you're then afforded when you have established a certain class of fatherhood, so to speak.
I guess, and I'm not saying it's fatal to your position for me, but I got to say, I don't agree in concept that you're talking about a federal constitutional analysis, and there's this sort of invocation of these sonorous tones about the parents in the federal constitution, and it's there. The federal constitution doesn't seem to think to itself, gee, I wonder what the different ways you describe fatherhood are in a state statutory scheme such as the one you're describing. I'm not sure the federal constitutional question hinges on the distinction you put in it. I'm not sure that means you lose, but I don't think the federal issue devolves to how Arizona's legislature decides to describe that, counsel.
I actually disagree. If you look at the Lair case, which is one that they relied heavily on in there, they do talk about these substantial steps, and I think in the Lair case, I can't remember if it's New York or Pennsylvania that's the underlying, but there's like 7 different classes of fathers, and they basically agree that strict compliance by the state court,
the court or the council?
Supreme Court, the U.S. Supreme Court agreed that compliance basically that those statutory framework for becoming a father and the different classes of father were constitutional, and it was constitutional for the underlying trial court to basically have strict compliance with those statutes.
But I think Lair's the 1983 case that's like the true abandoning case. That's like the no question you abandon from birth case.
Correct.
Right? Okay. I understand, counsel. Thank you.
I don't think I have anything else unless there's any other questions from the court.
I think we're good, counsel. Thank you.
Thank you.
You have 2 minutes, and we'll say 9 seconds.
Thank you. I want to start with the appellee's position, which, as I heard it, is 100% this case has to be determined on the category, the naming of the father. Are they a putative? Are they the actual parent? And that is just fundamentally incorrect, because if you look at the constitutional question, it's very clear that the courts have said over and over, if a putative father takes significant steps, then he attains the same constitutional due process rights as an actual father of baby X. And that's what we're talking about, is what is their constitutional rights.
But let's assume you're right about that. Doesn't that still require that 106G and J, as applied to father, failed to accord him fundamental fairness?
I think what that is a factor to consider in the totality of all the circumstances when you're looking at a constitutional question of fundamental fairness. It's a factor, but I don't think it's the only thing you look at. I think it's one of many factors.
But if the statute did accord fundamental fairness, how would you have a claim, even assuming that your client is the true father, which my hypotheticals to him presuppose? Why would you then have a claim if notice from the statute gives you fundamental fairness? How would you still win?
Because he had an ineffective assistance of counsel. He took steps to protect those rights, and he was given ineffective assistance of counsel, which means that the proceeding was fundamentally unfair to him. And just because I am out of time, I do want to say my final words here is that Corey's fate is in your hands. He can't bring a legal malpractice in. This is about the heart. Money is not going to cure what he has lost here. He has been divested of any opportunity to build a relationship with a child that might be his. And the only remedy is if you remand for further proceedings.
Thank you both very much for your helpful and excellent arguments. We will briefly stand at recess before hearing our next case. Thank you, everyone.